for our listeners, I thought I would just mention a couple of the other cases in your amicus brief that stood out to me. The VanDyke case, where apparently the panel, this was right after the DC versus Heller case in 2008, followed by McDonald in 2010. So this is in 2011. The Ninth Circuit panel granted plaintiff leave to amend in light of the recent Supreme Court decision. But then en banc took it up and said, no right to amend, just dismiss with prejudice. And then another case, Duncan versus Becerra in 2018, where the panel apparently in affirming a gun control legislation relied on Heller's dissent rather than the majority opinion, and yet there was no en banc review. And then we talked about kind of the getting them coming and going problem. You don't have a right to open carry, but when you get when you challenge a discretionary determination on concealed carry, the Ninth Circuit said, no, the Second Amendment doesn't protect the right to concealed carry, but then was silent about the prohibition on open carry, which effectively wrote the Second Amendment out of the Constitution as it concerned those plaintiffs. So those are some ones that stood out to me that I thought bore out your argument, and then Judge VanDyke's argument that, yeah, there does seem to be two different standards here when it comes to gun control measures seem to get the light touch, and pro Second Amendment decisions get the full en banc review.
Yeah, not a single, if the excuse was, hey, we're in a new world with this Second Amendment stuff, and the Supreme Court just made a ruling in 2008, and we kind of have to get this right. We're in the early stages, kind of like when the First Amendment first started getting heard by courts and evolving, or the jurisprudence was evolving. If that were the case, okay, but you have to at least be able to point to one case where there was an unfavorable opinion to sort of give credence to that, or to suggest that is actually what they're doing. But when it's 5 or 6, I forget what the score is, but 5 or 6 favorable opinions get en banc and 0 on the unfavorable, I think that there's something suspect there, and that's why we wrote the brief, and that's why I think Judge VanDyke will be vindicated. Perhaps not his tone, but his reasoning will be, for sure.